Yes, Miss Wise.
Large, my lord. My lords, my lady, first I can say that there have been discussions between Council about timetabling, unless my lords, my lady have so many questions for me in this very last chapter that I take longer. I would hope to be sitting down no later than 2:30, and that should leave 40 minutes or so each for the Lord Advocate and the Mothers' Council, and then a brief right of reply if she elects to have one by Mrs.
Good. Well, let's get going then. Thank you.
So just before lunch, I had been making submissions about Article 14 in particular and its interaction with Article 8, and of course what has been focused very much in the appellant submissions has been the procedural requirement of Article 8 and then 14 rather than a standalone Article 6 case. So continuing then with Article 14, in that context, or in that part of her issue 2 submission, the appellant relied heavily on Sahin against Germany and Zauniger against Germany, and I've taken, my lords and my lady, to the latter of those two. But what I say in relation to this is that those cases do no more than confirm that weighty reasons are, of course, required to justify a difference in treatment on the grounds of marital status or sex, but that each member state has a wide margin of appreciation on such issues. And I had, of course, now taken, my lords and my lady, to be against the United Kingdom, which concluded that such justification for different treatment exists in relevant UK legislation. And nothing said in Sahin detracts in my submission from that proposition. Sahin was concerned with the provisions of the German Code, the mother's veto being equivalent to a ban or exclusion. And Zauniger was the same. Any difference in treatment, I say, is easily justifiable if the overriding requirement to have the interests of the child as the paramount consideration is adhered to. And what I say is that the context of child protection strengthens rather than detracts from the justification, given the reasonable need to restrict those participating and being obliged under threat of criminal sanction of attending the children's hearings. Now, in relation to, that is all I would wish to say about Article 14 in conjunction, of course, with the written case. So far as Article 6 is concerned, given the focus of the discussion yesterday and the primary basis being the procedural requirements of Article 8, I would refer primarily to the written case on Article 6. There is one important point, and that is that there was no concession before the First Division that the appellant's Article 6 rights were engaged. And there may be some confusion or misunderstanding about the acceptance by the reporter on the basis of previous authorities such as S against Miller, when it was conceded that children's hearings were proceedings in which children's rights could be determined, and K against authority reporter in relation to a parent with parental responsibilities and rights. And of course, the whole point of the Article 6 argument in the First Division on the basis of McMichael was that this was not such a parent. Now, paragraph 53 of the respondent's case, at page 23 of the respondent's case, sets out in terms what the submission of the reporter was in the Inner House in relation to whether Article 6 was engaged, and my learned junior helpfully checked last night that was accurate in terms of what had been said. So there was no concession, and there remains no concession on that for obvious reasons. Briefly, in relation to McMichael, again, there was a focus perhaps on what was said to be sort of historic nature of that case, the fact that it was some time ago and that matters have moved on. But of course, the crux of the matter was that if your lordships and my lady accept that some differentiation, some process, the taking of a step, the filter is justifiable, then it's as justifiable today as it was in McMichael. The legislation applicable in McMichael, of course, had the welfare test as the paramount consideration and had the requirement to seek an order from the court and to justify that order on welfare, so it's analogous. In Authority Reporter against S, which will perhaps come to more in terms of the reading down, but on this point, of course, it was the obtaining of the order. It was having succeeded in obtaining an order that led the court to consider whether Article 6 rights were then engaged. It wasn't enough, just as it wasn't for Mr. B in the United Kingdom case, to raise a claim. You had to get an order. And in this case, the appellant was fully engaged. I don't want to rehearse that submission. That is all I would wish to say in relation to Article 6, other than it is already covered by both the written case and the submissions, of course, on the procedural requirements of Article 8. And I wish to turn to two further matters. One is issue 3 in the reading down, and then finally the question of example competent orders. And I've already put those before my lords and my lady, but if I could deal with those at the very end and turn now to reading down. The respondent's position is, and has consistently been, that even if any perceived incompatibility was identified, the only reading down that would solve that identifiable problem would be the words or contact in terms of a contact order. And as my Lord Hope has correctly pointed out in Authority Reporter against S.
I mean, you accept these additional words are right in terms.
Indeed so, yes. So the submission was consistently that it would be contact in terms of contact order, but clearly the respondent can have no difficulty with the addition of those words and has acted upon that and accepts the decision of the extra division in Authority Reporter against S, and that formulation.
What's tab number?
The tab number of Authority Reporter against S is 5. 5 in Volume 1.
Thank you.
The reading down comes towards the end. In the very last paragraph, my Lord, at paragraph 60 on page 778.
And it's covering a situation, as they explain, where the order is in place, but it hasn't actually been exercised for a period.
Yes, and on the facts, so there were two cases heard together in Authority Reporter against S. One of them was the S case, and the other, L against R. There was a difference between whether the contact had actually been exercised in terms of the contact order, and it was to cover that situation. Now, the respondent has no difficulty with that, and so reading down the words "or a right of contact" in terms of a contact order is the reading down that the Authority Reporter has now accepted.
So, I'm getting slightly lost. So,
yes.
What is it? What do you in the report against S? They said or contact in terms of contact order.
Yes.
And you're saying now.
Well, I think it's at letter H, isn't it? As far as the point is that they added
They added in the
these
words
additional
right.
words.
What they record is where effectively, I think both the Lord Advocate and the reporter had got to as a fallback position in relation to reading down.
Yeah.
And that's the first part. So for clarification, my Lord Roger, that is between G and H, and then further down they say, on further consideration, we think that to be clear and to cover the facts of cases such as an S and L, although there was a difference between the two, where there was in fact no contact for a period prior to the children's hearing in question, it would be necessary to imply at the relevant point or a right of contact in terms of a contact order, so that the subsection would read any person enjoying parental responsibilities or parental rights, or a right of contact in terms of contact order.
It's a happier way of putting it anyway, because you're looking to the terms of the order rather than to what actually happened.
Yes.
Just in the same way as in the first part of that formula, you've got something clear to hang on to rather than a factual inquiry.
Indeed. And the right of contact in terms of a contact order is stated in the alternative where one doesn't have parental responsibilities and rights because of the acceptance of my submission, Authority Reporter against S, that you don't have those rights just by virtue of a contact order.
Yes, yes.
Hence the use of the word or. So, so that reading down is acceptable. Now, the argument, as I understand it, is that it wouldn't solve, according to the appellant, the issue in this case. Now, those instructing me have given consideration to some of the thoughts that my Lord Hope expressed this morning about wordings if the court is against the respondent. my lords and my lady will have seen from the written case that no further reading down than that in authority against reporter is suggested by the respondent. What I wish to do, if I may, is comment upon the advantages and disadvantages of the various possible readings down if the court was to get to that stage.
It is worth noticing that this case, looking at the formula in S,
Yes.
it is a sort of Cheshire Cat situation, isn't it? I mean, you've got sometimes there's orders there, sometimes not.
Yes.
And that may be quite typical of cases,
Yes.
actually, from time to
Yes.
time. And one wonders whether,
Yes.
although it solved the problem in S and L,
Yes.
whether it's a thing that can really last for the foreseeable future.
Yes, that is what I would wish to address first. Where a parent, such as the appellant, has been to court and obtained a contact order, a right of contact under contact order, whether ad interim or final. The final case doesn't matter because then he would always be in. If it's an interim contact order, the question arises as to whether there is any difficulty with him. I think popping in and out was the expression that was used. Now, although as a matter of common sense, it may seem fair that if he's in, he should be in for all time, I do urge caution in that given the overriding requirement to, both in part 1 and part 2, always to act in accordance with the welfare test as the paramount consideration, one has to bear in mind that if an interim contact order is revoked, it can be assumed to have been revoked on welfare grounds. So there is that.
It could be. I'm sorry. I don't want to interrupt you too much, but of course it could be a very temporary revocation. In fact, in the circumstances that happened in this case, an incident had taken place, an assessment was thought to be necessary, and so you have a temporary. This happens a lot of times, and you're still coming in and out of proceedings that are nevertheless very important to you and your child.
If there's a concern about that, then I can see that a reading down that inserted the words "or has had,"
Having enjoyed.
I can see that that doesn't require the sort of rewriting of the legislation or too much reading into that I'm going to say the appellant's first reading down would require. The advantages of that sort of reading down, the has or has had a right of contact, in terms of a contact order, would be that it would provide the certainty that the reporter has consistently been looking for. It would in all cases mean that the welfare test had been applied by the court, which of course is one of the respondents' fundamental positions, that is the appropriate forum for that. And it would, as it happens, cover the situation of the present appellant. The disadvantage, I suppose, would be where you had very historic contact orders that hadn't been exercised for 10 years or had been revoked many years ago. So the person would then fall within the category of someone who had had a contact order historically, but it may have been such a long time ago and removed for such good reasons that issues would arise there. But I raise that simply as a point of possible disadvantage. Yes, but I can well see the merits if one was in the authority reporter against S category, but concerned about particularly interim orders, I think, being granted and revoked, where that can be done from time to time. And I simply point out that, of course, the welfare test must apply both in parts 1 and part 2.
So there are pluses and minuses about this.
There are pluses and minuses of it, but it has the overriding advantage, as the reading down an authority report against S, that the court applies the welfare test and makes the order, and that is what gives you the right to engage and to go into the children's hearing, and of course I accept that.
So if you contrast that with what was suggested, I think, or is being suggested
Yes.
Against you, is I think attached to head C, actually, isn't it, or similar to head C, which
Yes.
is the phrase, or appears to be a person who has a de facto family tie with the child. You would say what in answer to that?
I would say two main things in relation to the appellant's second proposed reading down, which is or appears to be a parent who has a de facto family tie. I can see that what the appellant is trying to do there is to some extent mimic the terms of Article 8, but it might be better to do so more simply by saying, or appears to be a parent who has family life with the child. Because if you have family life with the child, you have a right to respect for that life, so on and so forth, and you're in clear Article 8 territory. The problem, and the second point is that the problem with the second reading down for the appellant is there is less certainty, and of course it requires the reporter or the hearing to interpret it and decide whether or not there is family life.
And I suppose you might make the same comment about the Lord Advocate's suggestion at page 8, which is, or whose participation at a children's hearing is necessary to ensure compatibility with his human rights and so on.
Yes, I have to say, with the very greatest of respect, I have considerable difficulty with the reading down proposed by the Lord Advocate. This is a test that's challenged the highest courts in the land, if I may say so.
Yes.
And that particular wording, if it's a non-judicial forum
Yes.
that is interpreting it, in my respectful submission, is highly inappropriate. So I have great difficulty with that suggestion. But in relation to the two possibilities under discussion, the contact or has had contact in terms of a contact order.
Well, can I just say it's my fault entirely, I've just lost the plot on this bit. Why is it that, is it confined to people who have a contact in terms of contact order?
Yes.
I mean, why, if, the chap has been actually in practice having contact, why is that not enough? And everyone knows that. There's not in dispute.
This is back to the certainty of categories. Section 93 2BC is the one that looks at a de facto test, and that's where the appellant's second reading down would come in. But that then requires a determination by the reporter or ultimately the hearing rather than the court, which is why, in my submission, the contact order reading down is preferable.
But the same point as I made this morning is that where do you draw the line between actual charge and control, covered by subpara C, and contact? It's a very actual contact. It's a very narrow dividing line. He spends the whole day, the child spends the whole day with him once a week.
But then one might be in a joint charge and control situation.
But this is the point I'm putting to you.
Yes, but I accept that if that is the concern, the resolution of that concern is the appellant's alternate second reading down, but I would rather suggest the parent who has family life rather than a de facto family tie. Then the hearing starts to think, well, what do they mean de facto, and how do we analyse that? So there's a point of semantics there, and perhaps it would be better to mimic the terms of Article 8 but not refer to them. But so far as the respondent is concerned, the primary position is that the authority reporter against S reading down, perhaps with the words or has had a contact order, is preferable because the test is then set by the court in conjunction with the legislation.
Again, I'm just throwing out ideas and thinking aloud, but I'm looking at head C and just wondering whether one could just simply add in, after the words or control over, the words or has contact with. But I'll just leave that in there as a suggestion.
It may give more rise to disputes about whether somebody is having contact, and if so, in terms of what. And this
in this case, for example, the father regularly had, as I understand, had the child from 11 on a Friday or something until 6 on the Saturday, something of that sort.
in terms of the contact order.
Yes.
Yes.
Yes. Now, supposing that had just been done by agreement or something like that, and that was the position. Would you not say that he was a person who ordinarily had charge or control of the child?
Yeah, I have no difficulty with the idea that if somebody's having extensive care of the child, they might naturally fall within this anyway. It doesn't require any reading.
Yes.
And so the reading down arose in Authority Report against S because somebody had an order, they'd gone to court and obtained an order, they didn't fall within C, and it seemed then that they should be included. So those are my submissions in relation to those two possible readings down, one of which has been raised as a possibility, and the other of which is in the appellant's second reading down, the Lord Advocate's proposed reading down for reasons I've explained the respondent has difficulty with. I should respond perhaps to the submissions from the appellant in relation to the any parent reading down. Yeah. Which is the first proposal. And I say there are innumerable problems with that, and it is coming fairly close to the rewriting of the legislation of a sort that would be inconsistent with the scheme of the Act and inappropriate, and that's a reference to Guidan against Godin Mendoza, which your Lordships, my lady, have already been taken to. And in the respondent's case, there are a list of examples of the sort of people who would then be included under that reading down. In essence, those who'd had parental responsibilities and rights, but they had been taken away by the court. There is one small error in the respondent's case in that respect. I'm grateful to my learned friend, Mrs. Scott. It's a permanence order that should be referred to and not an adoption order as being another of the situations where they would be in. And that is at page 28 of the respondent's case at paragraph 73.
Sorry.
I'm not quite sure I picked that up yet. This is
Yes,
paragraph 73.
Yes. This is the proposed reading down that would, of any parent, which I say is a rewriting in any event and taking away the notion of responsibilities and rights. But if one simply had in 93(2)(ba) any parent, that would include parents who had A, been refused parental responsibilities on the welfare basis, B, had been deprived of their parental responsibilities on the making of a permanence order.
Ah,
What is that?
permanent.
It's where the parental responsibilities and rights are permanently taken away in respect of children in care. It's a new structure that's been introduced, and it extinguishes the parental responsibilities and rights. Takes away the parental responsibilities rights, but not in a way that an adoption order does, in that they are still, of course, the natural parent of the child.
You have a statutory reference in mind.
Yes, it's section 86.
It's not.
80. No.
I'm sure we'll find it.
Yes, so it's section 80 of the Adoption and Children Scotland Act 2007. Sorry, I thought it was 86.
Section 80.
80 of the Adoption and Children Scotland Act 2007.
Yes. Right.
And this is looking prospectively, of course, if this reading down was effective, these would be the consequences. The third one is in fact incorrect, that those where an adoption order has been made, natural parent in section 15 of the Children's Scotland Act 1995 is subject to the provisions that extinguish the parent from being a parent at all when an adoption order is made.
Yes.
I don't understand it, but if I delete the third one? Is that
Yes.
the short?
Delete it entirely, not modify it, just
Yes,
take it
just
out.
delete
Take it out.
it.
That's all right. That's fine.
And then the fourth one, or now the third one, if I can put it that way, is that it would include a parent who had no parental responsibilities and parental rights, had made no attempt to secure same, and whose participation in the children's hearings would be contrary to the welfare of the child. Yes. And there was a discussion earlier about natural parents, mothers or fathers, and whether they could have their parental risk, whether they could be deprived by order of court. And of course, that's Section 11 order. So those parents would then be in the children's hearing, even though a Section 11 order had been made depriving them of their parental responsibilities and rights, and that would apply equally to fathers and mothers. So for these reasons, I would urge the court against, if the court was at that stage of reading in the words any parent.
Yes.
That is all I wish to say in relation to any proposed reading down. Finally, Lord Roger, I think, asked for possible examples of what would have been competent orders. And this is back to the First Division at paragraph 70 saying, well, we thought about whether we should substitute a competent order, but we're conscious that the merits are going to prove. I hope, had put before my lords and my lady a single sheet of example competent orders. Copies have been passed to those instructing each of my learned friends. This is not intended to be comprehensive, and I should also say that the reporter is not engaged in framing orders of this sort. These are my suggestions. So very briefly, my lord, lest it be of assistance, that the first order would be, because of course only one of the parental responsibilities is required, to come in, makes an order ad interim in terms of section 11(2) B of the Children's Scotland Act 1995, imposing upon the pursuer the parental responsibility in respect of the child X to safeguard and promote the said child's health, development and welfare, but restricts the exercise of said parental responsibility to participation in proceedings before the children's hearing in respect of the said child. And the importance here is, of course, that if you have an order that on the face of it is just allowing somebody to go to a children's hearing, then you're not looking at it on this two-stage, well, does he satisfy the test to get parental responsibility? And if he does, do I need to restrict the exercise in any way? That order would satisfy both of those considerations. The second one is imposing parental responsibilities and giving rights.
So those are in perfectly general terms to begin with. Whereas
Yes.
The first one is picking up section 11A, isn't it?
Yes, it's imposing one parental responsibility and restricting its exercise. The second one is making what one might term the full order, which is what the appellant sought in the crave of the initial writ. And the order would be that you impose all of the parental responsibilities and rights, or the general parental responsibilities and rights, but limit the exercise of them to participation in proceedings in the children's hearing. And the third example given is imposing upon a party the parental responsibility to maintain personal relations and direct contact, and giving the corollary right, or the corresponding right rather, the parental right to maintain personal relations and direct contact with the child on a regular basis without any restriction as to exercise.
I'm sorry, it's my fault entirely, but what's the inwardness of sometimes giving only responsibilities and sometimes giving rights? I mean, how does that work? I mean,
it depends on the circumstances of the case, and what is in the best interest of the child. The safeguarding and promoting the child's health, education and welfare is a responsibility listed in section 1. But not a parental right. The rights are given to fulfil the responsibilities.
Yes.
So if you've been given the right to, well, let's say a parent's been given all the parental responsibilities, then you say, well, which of the rights do I need in order to fulfil those responsibilities? And one right that you might need is to regulate the child's residence, or you might not be granted. And so on. If the child's not living with you, you might require the right to maintain personal relations and direct contact. So there are circumstances in which one might impose a responsibility with no corresponding right, and there are situations where, on the application of the welfare test, the whole bundle of responsibilities and rights is thought to be appropriate. So these are three isolated examples on the basis of hypothetical facts.
But as long as you've given them the responsibility for the purposes of relevant person, that's enough.
Yes.
So if you want to achieve the objective of his participation in the children's hearing, again without being pejorative, you can tack it on to any one of these.
One could make, yes, such order as is appropriate, having regard to being satisfied on the test, and then deciding whether any limit on exercise is appropriate.
Well, let us suppose that the First Division was, the Inner Division was satisfied that the sheriff had addressed the overarching principles.
Yes.
And let us suppose there wasn't looming a further sheriff's hearing in which this question
Yes.
could have been debated. Would it have been appropriate to amend the order so as to bring it within section 1?
Yes, it's clear from paragraph 70 that this is something that the First Division might well have done.
Might well have done.
Yes, in paragraph 70 they say in terms.
So
they
if we
considered a
felt-
substitution to make it a competent order, because on review the court of course would have wide powers to do that, but it was specifically because the merits of the substance of the dispute were, so far as they were going to be litigated, that they thought it would be better for the sheriff to do that. They were concerned about not having the material.
Right.
And understandably, given the paramountcy of the welfare test, didn't want to do it in the abstract.
Yes.
And felt that it was better done by a court of first instance who had...
Underpinning all of that was, put it at its lowest, the reservations as to whether or not the sheriff had done it. If we come to the conclusion that the overwhelming likelihood is that the sheriff did do it, and if there is any deficiency in the order, is there anything to stop us from curing the terms of the order?
Any court scrutinising the review or suspension of an interlocutor that sees that while it may be that the interlocutor is incompetent but a perfectly competent one is there to be inserted could do so, but because children's lives are not static, because of the stringent requirements of the welfare test, I'm hesitating because it may be
I think that's
that my Lord's Lady would regard it as
Technically,
inappropriate.
it must be right. We have all the powers of the lower court.
Of course.
Well,
so the power is there, but there may be a concern that the current material to satisfy section 11.7 wouldn't be there, and
probably the far more pertinent question is, if we're satisfied that that is the situation, we could make it clear that in future an order in one of these terms would remove all doubt.
indeed so.
While also expressing the view that that is what the sheriff intended.
Yes. We can't remit to the sheriff because there isn't an appeal, so we are rather stuck with the nature of the case.
And that, in a sense, brings me to the concluding remarks I wanted to make, which is that clarity is important here, and it may be that there was a suggestion perhaps of some criticism of the reporter and why would the reporter take these actions, but you see the reporter's concern is that if someone is asserting a right to go to a hearing rather than on the face of an order saying it's in the best interest of the child for me to have the sort of responsibilities and rights in general terms, and I'm happy that their exercise be restricted on the one hand, and satisfying the welfare test on the other, that was the reporter's concern. The reporter has a duty and a responsibility to see that the test is fulfilled and that there are competent orders made. So I do hope that these examples are of such assistance.
If that is the case, I'm sure you're right, shouldn't there be some requirement on the parties to the sheriff court proceedings to intimate the order, or I mean, to the reporter?
Indeed, I can well see the force of that, and I'm told that routinely that's not the case, and that's one of the difficulties.
Well, that doesn't make any sense. I mean, because I don't understand. I mean, if the reporter is concerned about this, I'm sure she is. I mean, it would seem to me to make obvious sense.
Yes.
If the order is, especially in a case like this, where I assume part of the raison d'etre of the order is indeed to get into the. I mean, in fact, the raison d'etre of this order was to get in, and so it makes no sense to get an order and then not to intimate it.
Yes, indeed so, and I think the facts of this case do illustrate the unsatisfactory nature of that and of intimation, and I'm obliged to my Lord for those comments. It will be passed on. Now, unless there's anything else with which I can assist my Lords and my Lady, I am 5 minutes behind my promised time.
Thank you very much indeed. Mr. Bender, do you want to add anything?
My Lords, my Lady, I have nothing to add.
Thank you. Now, Miss Grenane, I think you follow next, you?
My Lady and my Lords, I will endeavour to be brief, and I'll endeavour to make 3 points. I adopt the submissions of the Reporters' Council, and my 3 points are in relation and in addition to the points that have already been made in the written argument. My position is that we maintain that the interlocutor is not meaningful, that it doesn't provide clarity, although it could have provided clarity, and it is helpful that we've now had a number of examples from my learned friend in relation to what may have been competent orders. I maintain the position that it's not meaningful and not competent, and I'm relying, and I don't understand my learned friend Mrs. Scott to be taking issue with this, I am relying on the decision of Lady Peyton in the Principal Reporter case, which is at tab 39. My understanding is that in the main, my learned friend Mrs. Scott's position is that the issue here is one of involvement of the father. And I would agree with your Lordship, Lord Kerr, that the whole aim of the interlocutor is to provide a vehicle for the father to get into the children's hearing.
Yeah.
And what then happened was that the father was involved in the children's hearing as a relevant person and was so treated for a number of years until the matter came before the courts again in 2009. But I would take my lady and your lordships to the core volume to page 169. And page 169 is a letter providing a list of the terms in which the father was involved in the children's hearing. And I make reference to it because clearly he is invited on 4 occasions, not as a relevant person, but he is invited into the children's hearing. And it's clear that when the grounds of referral and the facts are established, that he is aware that this proof is in the offing, because it's clear from the terms of page 169 that he's been invited in July of 2006 to the hearing, and we then find at page 156 of the core volume that the grounds of referral and the facts have been established. But when we look at page 156, we see that neither the mother nor the father are present at the proof hearing.
Did the father have any right to be there, given the
I'm going to deal with that.
I'm simply asking because I'm not quite sure how the statute actually works out. The reporter makes a reference
Yes.
to the sheriff entertains it, but who's got a right to be there, I haven't yet discovered.
Well, my position is that he did have a right at that time, and I'm going to take your lordships to the part of the Act which I say supports me in that. But it's of interest when we're looking at the involvement of the father, and that was something that gave the court concern yesterday, whether or not the father was involved when the interlocutor of the 11th of August 2006 was pronounced, in which the grounds were established and the facts contained were established. And it's clear on the reading of it that the only parties represented were a Mrs. Reid on behalf of the reporter and a curator ad litem at that stage. Now, and when we look at page 154 and 155, we have the statement of facts and the grounds which are subsequently agreed and established. And it's clear that the mother isn't represented on the 11th of August and takes no part in the discussion. And those instructing me, my lord and my lady, have informed me that if the curator ad litem on the 11th of August, having carried out her role as a curator ad litem and carried out investigations into the statement of facts, which we see at 154 and 155, had disputed any of the matters raised therein, then there would have been an evidential hearing and a proof. Now,
And the father would have been a necessary witness, would he?
and the father would have been a necessary witness. But my submission is that when we look at the history where he did have contact, and he had residential contact from a Friday into a Saturday, then my position is that when we look at the terms of section 93 to C, section 93B(c), that he could have appeared at the proof hearing on the 11th of August and sought to be admitted at that stage as a relevant person on the basis that, given the residential contact that he had enjoyed for years, that he was ordinarily a person having charge or control of the child for those purposes. Now,
How would he know about it?
well, that's the reason, my lord, why I gave you up page 169, because the father has been involved prior to the 11th of
I'm sorry,
August.
yes, I see.
My impression was that it was really continuing until the order of the 5th of May 2006, which suspended the interim contact order. Is that right?
That's right. The interim contact order was suspended on the 5th of May. But in my submission, and I'm advised by those instructing me, that they routinely turn up at evidential hearings such as this one and ask for their clients to be admitted. And there's then a discussion as to whether or not the person is or is not a relevant person. And the example I've been given is that they will turn up for fathers or for grandparents or for other people and will try to argue it.
So,
But
who is this who will turn up at what?
the proof hearing that we see
Yes.
on the 11th of August 2006,
Yeah.
my position is that there was nothing to stop the legal representatives of the father turning up at that proof hearing and making representations that he should be treated as a relevant person, given the history that he had the residential contact, overnight contact with the child, and that would get him into section 92 BC.
But how does he know about it?
Well, he knows about it because he's been invited to the children's hearings.
Yes, but he's not been invited to the proof hearing.
Well, that's right, but he doesn't need to be invited to the proof hearing.
Well, you need to know it's happening.
Well, my submission is that he would have known that it was happening by virtue of what we see at page 169, where if the issue is one of involvement in the proceedings, then clearly when we look at page 169, he is involved prior to becoming a relevant person. And by virtue of that involvement, he will then be aware that there is a proof hearing. And those advising me have told me that routinely persons will turn up and seek to be regarded as relevant persons at the proof hearing.
I'm sorry, I'm probably missing a trick here, but how do we get from page 169 to the conclusion that he was invited to the hearing of the 11th of August, or that he knew about it?
I didn't say that he had been invited
But
to the
or
proof
that he
hearing.
knew about it?
He wasn't at the hearing on the 20th of July. Well, we see that in page 158. At least there's no indication he was there.
That's right, he didn't attend that day.
which was the day in which they sent off to the sheriff.
That's the day on which they did the deal about which grounds would be accepted. The most important day from the father's point of view.
My understanding was that the father would have been aware of the proof hearing. And I simply make the point that he could have sought to have been regarded as a relevant person at that point.
How do you get in as a relevant person? How would you get in there?
Because by virtue of the historical residential contact that he had had with the child.
So you mean so C, is that right?
That's right.
So he appears to a person who ordinarily has charge of the control of the child. So if they'd asked themselves, does he ordinarily have care, control, the charge of the child? They would have said he had it.
Well, what we see happening is that the proof hearing on the 11th of August doesn't proceed because the curator agrees with the reporter on the grounds and statement of fact. And we then have a situation where on the 18th of August, he's given an order again for interim contact. My submission in relation to that is that he was involved and he could have attended at that time. Now, what is clear is that he continues to be involved. And he continues to be involved in both proceedings. And I think it's to be remembered here that there are proceedings in tandem.
Well, we've had that point stressed to us all day, I think.
Well,
What is exactly your status here? What are you arguing? What are you arguing?
my status is I am here on behalf of the mother.
I know that. But the mother knew all along that he had been appointed. The interlocutor had been pronounced.
Well, no, that's not true.
She was a party to it. She was a party to it.
My understanding is that the mother's agents changed, and that the mother wasn't fully aware of the extent to which he was or was not a relevant person.
Was she represented on the 27th of October? We were told this morning that she was.
Of course she was. And we were also told that the words P/P meant that the party was present.
Yes, but the point I'm making is that the mother's agents changed, and I am instructed that there was no indication in the file of papers that they received which stated the full extent of the interlocutor, and it only became apparent at the appeal proceedings in January 2009, and I have been instructed that the agents for the mother endeavoured to have this particular interlocutor recalled, but effectively were pipped at the post by the petition.
Well, they would have been in pretty deep water trying to do it, given that they didn't appeal it. I mean, you can't come back. The parties to the thing can't come back years later. I mean, the thing is absurd. I mean, I forbear to comment on suspension as a remedy in connection with an interlocutor which has been acted on for a number of years. I forbear to mention that in the case. But, I mean, for a party who has acquiesced in an accurate interlocutor, which, if she had been unhappy with, she could have appealed, for her then to come along and bring a suspension is a ridiculous situation.
I think, my Lord, that only when she obtained new representation was this issue raised. But in any event, this court is being asked to revisit something which is 4 years old.
I know.
And at the same time, it is to be remembered that when the First Division made their decision, it was against the backdrop of a forthcoming proof. And the proof had only been fixed because the mother's agents had asked for the proof to be fixed. I'm slightly moving off the points I was trying to make. But in essence, my position is that there were a number of remedies that were open to the father in order that he could continue with his involvement. And I say this with particular regard to the no contact orders that were made in the children's hearing, because there are a number of instances where no contact orders are pronounced, and he does not challenge that. And he doesn't challenge it until 2009. He could have sought an evidential hearing, and this is something that your ladyship raised both today and yesterday. If the father's position is that he has been done an injustice because the mother may have fabricated this or fabricated statements made by the child in order to frustrate and obstruct the father, then I would suggest that the case cries out for an evidential hearing. And it's clear when we look at section 51 of the Children's Scotland Act 1995 that he could have, on each occasion, sought to bring this matter before the court and did not do so. He could have had his evidential hearing and for whatever reason did not do that.
Well, I'm still wondering just how the legislation fits in with what you're saying. Can you just guide me on this? If we look at section 68, which is the provision that's dealing with the application for grounds of referral.
Yes.
The first point which I'm still unclear about is whether the father, not being a relevant person, has any right to be there. You say he is a relevant person.
I say that he could have come along and argued that he was a relevant person.
To the sheriff.
To the sheriff. That was open to him to do, and he did not do it. In addition to that, he could have appealed against the no contact orders of the children's hearing, and in terms of section 51, those appeals would have been heard by the sheriff. But it's clear when we look at section 51.
Always providing that nobody had brought an exocet to say that he wasn't a relevant person.
But the fact is, my lord, that he's being treated as a relevant person by virtue of the interlocutor.
I'm only too well aware of that.
He's being treated as a relevant person, but at the same time, there are a number of no contact orders being pronounced against him. And if the issue is one of fairness to him in his ability, these submissions arise out of Lord Hope's comments yesterday about the grounds of referral and the facts being established without the presence of the father.
Yes.
And the inability then of the father to vindicate himself and clear his name effectively. And I'm saying that at each occasion when a no contact order was pronounced, he could have sought an evidential hearing in respect of that in terms of section 51(3), but he did not do that. If we're looking at the involvement of the father and the remedies that are available to the father, then there are remedies that are available. And in addition to section 51 and section 51(3), I say, and I don't agree with Lord Roger in this, I say that he had a remedy under section 85.
Well, he appealed, didn't he, eventually?
He eventually appealed.
In January 2009 or thereabouts. And that appeal was opposed on the ground he had no interest to do it.
In 2009 he appealed, but
Yes.
that's after we've got no contact orders from 2007. It's all very well for my learned friend Mrs. Scott to say that eventually the patience of this father was tried beyond belief. But at no point has the court been addressed as to why, in relation to the tandem proceedings in the Sheriff Court, why the father sold the no contact situation and did not recall the cyst in the Sheriff Court proceedings. I'm coming on to the Sheriff Court proceedings, but I say that this is a father who was involved, and he could have continued to be involved by virtue of Section 51 and also Section 85. He could have continued to be involved in the children's hearing, and he chose not to do that.
Well, I don't want to inhibit you too much, but there's a good deal about this in your written case.
Indeed, my
and
lord.
time is moving on. I think we understand very clearly the point you're making.
Right. Well, in light of that, I think it's to be remembered that the decision of the First Division was against the backdrop of a hearing and evidential hearing coming on the merits. And that, my lord, brings us up to the proof that was discharged and the question that was asked yesterday as to why the proof was discharged. And my position, having been present when the motion for discharge was heard on behalf of the father, the mother's position at that was that the proof should go ahead because it was in the interests of the child that the father's claim for parental rights and responsibilities be heard by the court and that the court determine what they made of his claim for contact. Now, the father did not wish to proceed with his proof in May of this year, and the reason he did not wish to proceed with the proof was that a note was handed up to the sheriff from senior counsel, which in essence, I haven't seen it, but in essence the court was addressed that because the Supreme Court was being asked to revisit the interlocutor of 2006, that was a good reason for not proceeding with the proof. And in my submission, my lords, that's where the difficulty lies here, because although we've heard submissions about what may or may not be in the best interests of the child, clearly, for all parties, there should be a hearing on the facts in respect of the father's claim in the sheriff court action, because it's to be remembered that although we've been arguing for 2 days over whether he's in or out of the children's hearing, the thing to be remembered is that his application for parental rights and responsibilities in the sheriff court is still alive. It may be sisted. My understanding is that there's a motion to be heard at the end of this month to have a new proof diet fixed.
Well, there is a limit to the extent to which we can become involved in all of this. It's not really for us to pass comment on that matter, is it? I mean, we've got very specific issues of law to consider here.
Well, there are very specific issues of law, but at the end of the day, the court is to be minded as to anything that it pronounces in relation to whether or not it's in the best interest of the child. And my submission is that this court can effectively do what it likes, but the child's welfare and interests are still out there, and they're still out there for determination. And unlike the various German cases that were cited yesterday, those, in essence, were fact-specific. The facts had been heard in them. The facts have not been heard in this case. And the only point that I would make, my lords and my lady, is that in terms of the 1995 Act, and this is not covered in my written case, in terms of the 1995 Act, section 73(6), it is open. It is open to the mother. It is open to the mother to require a review of the supervision requirement. And my understanding is that if those instructing me go down this route and are successful, then the supervision requirement flies off. And that's the end of the matter. And we're back then in the sheriff court, in the sheriff court proof proceedings. You see, on one view, my lords and my lady, and I will keep to the time, if the proof had gone ahead in May of this year, and the sheriff had pronounced findings in fact, then in some respects, what the court's being asked to do by the appellant today and yesterday would have been neither here nor there. because the father's Article 6 and Article 8 rights, and any other rights he may have had, would have been fully aired and fully vindicated by not seeking to proceed with the proof, but instead going down this route. What is going to happen is that at some date in the future, we will still need to have a proof in respect of what's in the best interests of the child. And that's whether it's an evidential hearing arising out of the children's hearing system or it's a proof hearing in the sheriff court. Because I don't understand that the father has dropped his claim for parental rights and responsibilities and contact.
I suppose we're entitled to bear in mind, aren't we, that the reason why we're here is because it was a reporter who brought proceedings for suspension of the interlocutor. It wasn't
right.
the father's initiative.
That's
but of course
right.
he resists the petition when brought.
That's right. But by the same token, the proceedings from which this interlocutor emanated are still live. They may have been sistered temporarily, but they're still live. And in my submission, my lords and my lady, the proof wasn't discharged because the sheriff didn't know what to do. The proof was discharged because the father chose not to proceed with the proof.
Well, there we are.
Unless there's anything else that you wish to be addressed on.
I don't think so. Thank you very much, Mr. Shelton.
My lady, my lords, I have nothing to add.
Thank you. Now, Mr. Johnson.
My lady, my lords, the Lord Advocate's interest in this case is confined to the question of convention rights, and in particular to resisting any declarator of incompatibility. So that on the question whether the order at issue in this case is competent, I don't have any submissions to make. It does, of course, the matter comes before the court in a somewhat unusual way, as my Lord in the Chair remarked just a moment ago, that what we're actually concerned with is proceedings taken by a reporter seeking reduction or suspension, rather, of an interlocutor. And that if the court were minded or to come to the view that this interlocutor were actually entirely competent, then one might think the other issues with which the court has been has had submissions over the last day or two really don't arise. If the interlocutor is competent, then so be it. However, that is not what I'm here to discuss. My argument, as my lords and my lady will have seen from the written case, is that the particular section in issue is not incompatible with the Human Rights Act, and alternatively, if it is, it can be read so as to make it compatible. Like any other contention about breach of convention rights, this question is to be approached not in the abstract, but in relation to the actual violation of which this particular appellant complains. And I won't go to any case law on that, but it's referred to in the written case in paragraph 2.1. Now, Ms. Wise has already covered in detail the convention rights issues, and there's no point in my simply going over the same ground. And for that reason, not least, I can be really quite brief. As I understand the case for the appellant, it's not that unmarried fathers should automatically have parental rights and responsibilities. Instead, it's that they should automatically participate in the hearing. Now, I would resist that proposition, and it seems to me that there are several strands to the argument which come together to lead one to the opposite conclusion. So I'll take these in turn, I think all quite briefly. The first one is the distinction between married and unmarried fathers. Now, the court has already seen that distinction is legitimate for some purposes. And on the case law that we've seen, this is one of them. The starting point is for these purposes, McMichael, which is number 66 in the bundle. I don't think I need go to any of the cases I'm about to mention. I think Mrs. Scott suggested, or at least implied, that McMichael was something of a dead end, or had at least been overtaken by developments in society. In my submission, that's not an accurate reflection of the treatment that McMichael has actually received since. If I remind the court, we saw in Miss Wise's submission, we saw the case of B in 2000, that's number 56 in the bundle, the one to do with the Children's Act 1989. Equally, there are two more recent cases in the bundle from Strasbourg which have not been referred to and which I don't think I need go to either, other than to give the references. The first one is number 69, the case of PM against the UK. Now that's a case from 2006, where in paragraph 28 the court records the McMichael decision in its reasoning. And the same may be said of a case which is mentioned in the Lord Advocate's written case, number 68, the case of Petrov against Bulgaria from 2008, where paragraph 55 does the same thing. And equally, as Miss Wise showed my lady and my lords this morning, we saw in the Re-G case from the House of Lords in 2008 a recognition of the fact that McMichael is authority for the proposition that in certain circumstances it's legitimate to draw a distinction between married and unmarried people. So that's the first strand of the argument, as it were. The second one, I'm reluctant to say how many strands there are because I always lose track of the number. But
we might remind you.
The second one is that, so far as Article 8 is concerned, the Strasbourg case law is that a de facto family tie may or may not amount to a family life. And as the court says, it depends on the facts. I'm not sure the court has been taken to the case of Lebink, and it may not be necessary to look at it, but it's number 64, Lebink against the Netherlands, paragraphs 35 to 37. And it really, for my purposes, says little more than what I've just said, that it's a question of fact.
Could we perhaps just have a quick look at that? You say paragraph
It's 35 to
35?
37, my lord, and I think it's volume 3.
Five.
Oh, I'm sorry, it's the paragraph numbers. It's number 64. So.
I think you refer in your case to another paragraph, to 76 as well. Is that a misprint?
What paragraph is it?
My lord, it's paragraph 35 to 37.
Thank you.
And the court will see there, at the beginning of 35, the court recalls that the notion of family life under Article 8 is not confined to marriage-based relationships and may encompass other de facto family ties where the parties are living together out of wedlock. And then it discusses relationship. 36, we go on to see that, as a rule, cohabitation may be a requirement for such a relationship. The existence or non-existence of family life for the purposes of Article 8 is essentially a question of fact, depending upon the real existence in practice of close personal ties. And then I think the only other point to take from that is towards the end of 37, the last 4 lines, where it says that the court does not agree with the applicant that a mere biological kinship without any further legal or factual elements indicating the existence of a close personal relationship should be regarded as sufficient. So that is the second strand then, that a de facto family tie may or may not engage Article 8. It's a question, as the court puts it there, of looking at the real existence in practice of close personal ties, which, as they say, is a question of fact. Thirdly, a point that's been mentioned already, the Article 8 right of a parent may need, in certain cases, to yield to the rights of the child. And since this has been mentioned already, I'll just confine myself to referring to number 70, the Sahin case where that point is made at paragraph 67. And so it follows from that third point that, at least so far as Article 8 is concerned, there are circumstances in which a parent may not be able to participate when regard is had to the welfare of the child. And one bears in mind, of course, in the field of child welfare, the role of the relevant person is about much more than his or her own interests or rights. The relevant person is there to assist the children's hearing in the determination of, or in the making of decisions about the child's welfare. That's why they need to hear from the relevant person. And so the relevant person is there at least as much in the interest of the child as in their own interests. However, the main point I make under that heading is that the parent's rights may sometimes need to yield to those of the child.
I mean, under Scots law, as I understand, looking at the statute, if you read it carefully, they only have these rights in order to discharge the responsibilities. I mean, it's a slightly bleak attitude to parents' rights, but that's the one which has been enacted.
Yes. Yes, indeed. I'm not sure I can usefully say much more to that, but yes, I suppose it focuses very sharply, as my Lord puts it, the fact that we are in a statute that is where the real emphasis is on children and their rights, and other people play their part in ensuring that the welfare of the children is treated with paramount respect and importance. So taking those 3 points together, we come then to the fourth one, the question of entitlement to participate. If it's not automatic, it needs clearly to be resolved in a proportionate manner. And the procedure in this Act is, in my submission, a proportionate manner of serving a legitimate aim. Now, Counsel for the Reporter has already dealt with the question of the legitimate aim. I think, while happy to accept the way in which she put the aim, I would emphasise the overarching aim of trying to establish a system that works optimally for the welfare of the child. One of the considerations that is taken into account in setting up the system under this legislation is to make sure that the right people are at the hearing. Now, to some extent, that means not having too many people around the table. But in my submission, it goes further than that. It's more important that the right people are there, the ones who can actually inform the taking of a wise decision in relation to the welfare of the particular child.
Why were they wrong then and right now? Under the Act, under the 2006 Act?
Well, my Lord, I'm not sure I can say much about that other than that obviously views about social policy change. And
yeah, but we've got to consider it as today.
Yes.
And the question is, you know, if it's been recognised for children born after a certain date, then, you know,
but if
has it hampered these children's hearing? Are they labouring under a disadvantage of having this father there? If not, why would a children's hearing in this case labour by having a child, their father there? I mean, that's the issue, isn't it?
Yes, of course, I understand that, my Lord. That's partly why I don't particularly put the emphasis on the numbers of people. Rather, that, of course, if times move on and legislation changes, one may, of course, have a slightly greater or slightly smaller circle of people who at that time are regarded as the appropriate, relevant people.
But presumably the later legislation had as its underpinning the view that the optimal system that works for the child included the father, who was the unwed father.
At least if he jointly registered the birth.
Right,
yes.
right.
Well, that's absolutely right, and indeed
why should it be regarded as the optimal system before 2006, but the suboptimal post 2006?
Well, I do take the point that the court is considering the position now, but equally the court has to take into account the fact that we're dealing with the legislation so far as applicable in this case, the pre-2006 legislation.
Well,
And so
you say something about this in the last sentence of paragraph 2.17 of your written case, and I haven't fully understood what you say there. You say the decision not to make it retrospective was in the interests of legal certainty, not unsettling prior arrangements. But
my Lord, yes, much of this material, if the court
can I
wishes-
just finish the question? I mean, the point really is that the system we're looking at, the children's hearing system, isn't frozen at any particular point of time. It's an ongoing process. And the legislation, of course, comes into effect at a given date. But I can't for myself see the reason why, in the interests of legal certainty, you should cut the shutter down where you have and not include the past people as well as the present, given that there's an ongoing process involving children and their welfare.
Could I just follow that up, Mr. Johnston? Because it did occur to me that we are just looking at one particular aspect of this.
Yes.
We're looking at the effect on whether or not you are a related person. But of course, this change was a change to the automatic initial allocation of parental responsibilities and parental rights. And to do that retrospectively would be a very different thing from simply to do it for the purpose of participation in legal proceedings.
Yeah.
I'm grateful to Milady for making that point.
It should
Very
have
well been
written into the written case. But,
It's,
do we get any help from the documents you refer to?
My Lord, yes, there is. I can take my Lord's Milady to them, or simply give
Just a reference would
paragraph
be enough,
numbers.
I think.
I think that the most useful one, I would say, is these are all consultation papers. The most useful one, since it comes at the end of one of the series, is number 79, where the paragraphs are particular paragraphs of 2.12 to 14 and 16 and 18.
Yes.
But for completeness, I think I would also add in number 77, paragraphs 5.5.1 following, and in number 76, page 14.
Thank you.
And what they do show is that the question of retrospectivity was considered very closely over a number of consultative exercises. The point that Lady Hale made a moment ago was one of the ones that weighed most heavily in the balance, that to make this retrospective would actually rearrange family arrangements that had been entered into on a particular basis.
Yes, I see.
Equally, there's the consideration that's been referred to from time to time that being a relevant person carries with it an obligation covered by a criminal sanction to attend the hearing unless
Was there any
released from the
consideration given
obligation.
to the point, specifically in connection with children's hearings?
I don't believe so, my Lord. No, I think it was
It's the general one which Lady
part
Hale...
of, yes, part of a
focused
more
on.
general rearrangement of the law applying to children. So that while obviously there is now a larger category of relevant persons than there was there, that is the rationale for not making the new legislation apply to earlier cases, of which this is one. In relation to legitimate aim, which is the fourth point I'm currently on, the other point I would make, simply reminding the court of the G case that we looked at earlier today, is that it refers, in relation to the Strasbourg cases, of course, to the state's margin of appreciation. In domestic terms, some of the cases call that the legislature's discretionary area of judgment, the term deference having apparently fallen from favour. So the point I would make is that the detail of how to construct a system where the rights of the various interested parties are respected is, I would submit, a matter clearly in the field of social policy. The social policy adopted by the legislature here has, as we've seen, varied over the years, but the version with which we're concerned was a policy that the people mentioned in section 93 should be relevant persons, and that status should not extend more widely.
Well, I suppose the question is whether whether the solution is sufficiently sensitive to meet the facts of this particular case. I mean, this is a point you really make in 2.1 of your own submissions.
Yes. My submission is that clearly I'm coming on to comment in slightly more detail on how the procedure works, albeit Ms Wise has covered it very thoroughly. But my submission is that it is sufficiently sensitive because it does not set the hurdle very high, and it does not, putting it a different way, it does not result in a very narrow gateway or one that's very difficult to negotiate. And I say that because we have, of course, already seen that application to the court is just one way in which a person in the appellant's situation may acquire parental rights and responsibilities or may become a relevant person. In the background, one always has the question of an agreement with the mother. But if all that is required is to apply to the sheriff then is under an obligation to apply the welfare principles of section 11.7 in the particular circumstances. Furthermore, the sheriff is, of course, necessarily mindful of his duties as a public authority under the Human Rights Act. So one should expect that a full respect would be given to the human rights of those who are interested in the case. And if one takes those points together, then the question would come to be, why would the sheriff refuse this kind of order? And the answer must be if he or she took the view that making it was not in the best interests of the child, either because it would be better to make no order or that it would be better not to make this order. And I contrast this, as my learned friend Miss Wise did, with the blanket exclusion that we saw the House of Lords found to be objectionable in the G case. Here there are two differences. We're concerned with a case that's considered on its own terms rather than being a matter of unwavering policy. And secondly, we're concerned just with the initial allocation, to use Lady Hale's phrase, and not exclusion for all time. And as I said in my submission, this solution is, I would submit, sensitive enough because it allows, for example, as we know after the S case, it allows a person who has a contact order, or a person in the appellant's situation with a contact order, to be a relevant person. And as the court is aware, a contact order is not necessarily one that grants a great deal of time in contact. It may, as we've heard, not even be physical contact. But nonetheless, a contact order is sufficient. Equally, and a fortiori, if the court is of the view that the interlocutor that's an issue in these proceedings is competent, then that is a very limited form of order that nonetheless entitles the appellant to participate. So as I say, if that's competent, then the bar or hurdle is set really quite low, and one cannot conceive of any reason why
How does it work in practice? Supposing that the mother says that the child has returned and made an allegation along the lines we see in this case, and says she's going off to the children's hearing. She's going to go to the reporter and all that, and there's going to be a children's hearing about that. And the father then says, well, I would like to go to that, so he goes to the sheriff. And the mother turns up. It's intimated, and the mother turns up, and she says what she said in the thing. Now, what does the sheriff do at that point?
In relation to...
Into this, because he, as you say, has got to be satisfied that it would be in the interest of the child,
Yes.
and that she says it's definitely not in the interest of the child because this is a man who does these things. Now, what does the sheriff do at that situation, knowing that next week there's to be a children's hearing on this matter?
Well,
what does he actually do, the sheriff, he or she actually do?
I'm not sure there's an easy answer to that, given the division of responsibilities between the children's hearing and the sheriff court. The sheriff.
A difficult answer then. What's the difficult?
The difficult answer is that if the sheriff thought that the evidence justified, or the submissions, so far as he could find common ground in them, justified making an order, he could do that. Equally, he could simply take the view from the material before him that the focus is always on the welfare of the child. Nothing has been put forward. If one thinks perhaps of the Sahin case, where it was suggested that the presence of the unmarried father could be a disturbance or disruption to the hearing, nothing of that sort had been put forward. There was no reason why the father's rights should be seen as adverse to the child's own rights. I don't know precisely how sheriffs work. It would not surprise me if they worked with my Lord's own working hypothesis that unless there's a good reason not to...
Mother says there's a very good reason not to.
Yes. Well, these, of course, these are all cases that are contingent on particular arguments that one can...
It's just, I don't find it... the theory is lovely. You just go along and ask the sheriff to pronounce an order and then you'll get in. But, the trouble is that in a contested situation, it's not going to be as easy as that, and then the trouble is the sheriff can do nothing. He can't say, as I understand it, can't say anything to the children's panel to delay any determination.
Yes.
I thought that it's quite a good example of the problem, what happened on the 5th of May of 2006 in this case, because the sheriff, no doubt on information provided, suspends the interim order and appoints somebody to investigate and report. So the whole thing is frozen for a time being until he gets his report and has better information about the facts. Meantime, contact is suspended.
Yes.
And then the solution of the contact order disappears.
Yes, I follow that. The difficulty is I suppose the two imperatives are to make the right decision as quickly as possible, and secondly, to make it on the evidence as good as possible. Yeah. And those, to some extent, are necessarily in conflict, because getting the best evidence takes time. So here, as my Lord says, what apparently was thought to be the best solution was to investigate the facts. There's nothing, I would say, I'll come back to this, there's nothing unusual about the need, of course, to investigate facts. No. One might, for example, if one were in the case of disputed paternity, one might equally have a round of proceedings before one got into this kind of debate. Equally, a point I made earlier, if on the Strasbourg jurisprudence, the question whether there is a de facto family tie is a matter for evidence, then if, for example, an applicant were relying on his Article 8 rights to be included as a relevant person, he would need somehow to satisfy the court that he actually had those rights as a matter of fact by producing evidence as to the nature and extent of his relationship with the child.
But in any case where he had actually lived with the child, or had the child visiting or staying with him for any length of time, it's going to be very hard to suggest that there isn't family life.
Yes.
I mean, it's not a very high hurdle, is what I'm saying, to demonstrate family life when you're a parent.
Yes. I think that the more general point I would make in that connection is that here, as I understand it, the appellant is complaining that his Article 8 rights are not being respected because of this procedure. And so the question is, does he have any Article 8 rights? That is something, it may not be difficult to show, but it is, as the Strasbourg cases show, it's something that would need to be established as a question of fact before one could go any further. And that would necessarily involve a factual determination. One might argue about whether that determination is best made in children's hearing or by the court. But the fact is, in my submission, conceptually, the two stages that we have for unmarried fathers in the legislation as it then stood are not conceptually different from the sort of point that we've been discussing with my lady and my lords now, that one may need to go through an earlier stage to satisfy the court that something is appropriate before getting into the children's hearing. And as I say, whether that is establishing paternity, whether it's establishing the actual fact of family life, in my submission there's nothing intrinsically incompatible in the convention sense in requiring an unmarried father to go through that process in order to come in to the scope of Section 93. So that my submission is that allowing for the discretionary area of judgment available to the legislature, taking into account the range of fathers who will not need to go through this procedure and the way in which those who do can be dealt with expeditiously, as Ms. Wise explained, that this legislation is quite compatible with convention rights. I suppose fundamentally because convention rights depend on establishing the facts on which they rest. So that's broadly all I wish.
It would be much easier, though, wouldn't it, if it was somehow possible to establish your convention rights before the train left the station. I mean, the trouble with this one is you can't get onto the platform. The train leaves before you can get onto the platform because you're kept behind the barrier. And meanwhile, everything's going on. I mean, that's the problem about that particular submission, as I see it.
Yes. I understand, of course, one can't shrink from the fact that in particular cases, things should or could perhaps even have been done more expeditiously. As a matter of principle, however, I really just come back to the points I've already made, that as a matter of fact, one needs to establish whether these convention rights are engaged. That may require an evidential assessment by somebody. That may necessarily delay things before a person can be treated as a relevant person or held to be a relevant person. Clearly, if matters move on, that's regrettable, but in my submission it doesn't mean that the two-stage arrangement is of itself incompatible with convention rights. And I may say, of course, if one goes back to McMichael, and perhaps I should go back to McMichael, which is number 66 in, I think, volume 6. The European Court itself took no issue with the two-stage process, as we can see from paragraph 77.
Which is the one the First Division referred to.
Yes. And my lords and my lady are, I know, familiar with this. I don't know if the whole of it was read, but as we can see from the final paragraph in paragraph 77, it's said that even to the extent that the first applicant, that's the father, could claim civil rights under Scots law in respect of the child, the care proceedings in question did not involve the determination of any of those rights, since he had not taken the requisite prior step of seeking to obtain legal recognition of his status as a father. And it distinguished the Keegan case. But what I would take from that, I mean, clearly we're talking about Article 6, but what I take from that is that the court has, of course, reviewed the question in light of the two-stage procedure, considered whether there is an incompatibility in relation to the various convention rights, and it doesn't express any reservations about this two-stage operation. The reservations are all to do with the disclosure of information and so forth. Now, in relation to Article 6, I'm sorry.
Yes, no.
In relation to Article 6, Ms. Wise has covered this ground very thoroughly in relation to the continuing role of the Sheriff Court. And I think the only other point I would make, which I've touched on already, is that so far as the claim to engagement of Article 6 rests on Article 8 of the Convention, which was one of the bases on which I think Mrs. Scott approached it, of course that depends, as I've said already, on the prior assessment of whether a de facto family tie amounts to family life. If it does amount to family life, then Article 8 is engaged, and one can then argue that there being a civil right, Article 6 may similarly be engaged. It may, of course, not advance matters much further, given that, as the Court has already observed, I think yesterday, Article 8 has its own procedural protections. So my submission fundamentally on those two articles is that the two-stage process is well within the discretionary area of judgment and accords with the Strasbourg jurisprudence which I've referred to. So far as Article 14 is concerned, I've very little to say. I remind my lords and my lady, only of the various cases that I mentioned earlier in my submission about the legitimacy of distinguishing according to unmarried or married status. And secondly, I would mention again the Zaunegger case, which is number 73. I entirely support the submissions that were made by Ms. Wise in relation to that. And I would emphasise that although the court there was at pains in paragraph 60 to say that times change, fewer people get married nowadays than did, nonetheless it did not in any way attack the distinction between married and unmarried persons, or fathers rather. And as Ms. Wise has explained, the actual decision is based, as the court says in terms in paragraph 63, the actual decision is based on proportionality. There it wasn't a case about a blanket ban, but it was a case that there was an absolute requirement for the mother to consent in these circumstances. And as Lady Hale said earlier, that it's not uncommon experience that she may raise an unreasonable obstruction. So that clearly was a fundamental problem with the system in Germany then, and it was for that reason, as I understand the case, that the court found the German solution to be in breach of the applicant's rights. Here, however, we don't have any situation of somebody having an absolute veto. We have a right to apply to an independent tribunal, which, if satisfied on the welfare principle, will accord the applicant what he needs. My only other point on Article 14, I think I've already made, and this was simply to observe by reference to the Scottish Law Commission and other consultation papers that these issues have been under discussion for years, been consulted on very widely, and as my lords and lady will see from reading the discussion papers, quite widely divergent views were put before the legislature for consideration. Nonetheless, in spite of encouragement simply to scrap any distinction between unmarried and married fathers for all purposes, the legislature chose not to do that. And in my submission, it's well within their discretionary area of judgment when one recognises that we're squarely in the field of social policy. So I think that's all I would say about Article 14. In relation to the reading down, which clearly my primary submission is that it's not necessary to read this legislation down because the convention rights are taken into account when the sheriff considers whether to make an order. Not only does he need to consider the welfare principle, but he needs to consider other people's convention rights if they're going to be affected by the order. That, in my submission, is all that needs to be done to comply with the convention. However, if the court doesn't accept that, then I turn to the various versions of reading down. So far as reading down to say parent simplicator is concerned, for the reasons given by Miss Wise, I would submit that that is too wide. It causes problems that she identified in her written case. So far as the second proposal for the appellant is concerned, my submission is that that's also too wide.
Which one is that? I'm sorry.
That's the one about a de facto family time law.
Yeah.
And the reason I say it's too wide is that my lady and my lords will recall from the Lebink case that the European Court holds that a de facto family tie may amount to family life, but equally it may not. So to read this as covering all persons with de facto ties would actually be reading it more broadly than is required in order to comply with the convention. Rather, and this was discussed with Miss Wise, rather the need is to protect those who have family life within Article 8 rather than someone who has a de facto family tie. And that, of course, leads me on to the second reading. I think the first one on contact orders is self-explanatory in the written case, but the second reading I would accept it I don't know if question begging is quite the right word for it. Certainly it's not one I would choose, but I would accept it doesn't tell the chairman of the hearing or those who have to make the decision as much as one would ideally like to do.
Sorry, we're talking about your paragraph 3.3.
Yes, that's right, my lord. We're talking about the reading down to include those whose participation is necessary out of respect for their convention rights.
Yes.
And clearly one would like to phrase it in as precise a form as possible. The difficulty that we've had in doing so is that one wants to take account of Article 8, family life rights. It might be thought, however, that to limit it to Article 8 was to limit it too much. If there were considerations arising from other articles of the Convention, particularly, I suppose, 14, potentially 6, I suspect others are less likely to arise. And it was, I think, criticised, although quite gently, by Miss Wise as being unhelpful to those who had to make the decision. I would simply observe, though, if we're talking here about the decision being made either by a sheriff or by the children's hearing, both are regarded as courts, both are therefore public authorities under the Human Rights Act. It would be an odd suggestion that they could not be entrusted with an assessment of whether the rights in issue were engaged, subject, of course, to the need to clarify the facts.
Might have to have a whole new training module
Well,
for children hearing members, is that right?
Well,
And all the articles, all the possible articles in the...
Well, I don't have... I'm quite willing for it to be read more narrowly. I'm simply trying to explain to the court why it was thought that it might be unwise to limit it too much.
The Scottish Executive was trying to save money rather than anything else. I think that sounds terribly difficult in practice for tribunal chairman. I'm sure that's what...
Again, my ignorance displays itself. Are they legally qualified chairman of the...
No, they're not, my lord, no. I think... obviously, I need to face up to the difficulty in getting this to work practically. Miss Wise, I think, suggested that family life itself would cause too many problems. But in my submission, if the court found more convincing a reading down that related purely to Article 8, then I simply remind them of the fact that the Lebbink case requires, in this kind of situation, evidential assessment.
Yeah.
And in my submission, an evidential assessment of that kind would clearly on the authorities be compatible. And therefore, it seems to me that some version that made clear that one was taking due account of the family life of the applicant rather than, say, his de facto legal tie would seem to meet the case. I'm advised...
What's a de facto legal tie?
Well, it's simply the expression the European cases use, typically to refer to the relationship between an unmarried father and the child.
You said de facto legal tie.
It's not legal. It's
Tie.
a family tie.
Oh, I'm sorry,
ties.
I didn't. I obviously wasn't listening to what I was saying. I apologise. Yes, I meant to say de facto family tie.
Oh, good.
I do apologise.
That's a relief.
I wasn't aware I'd said that.
I must say, the more different possibilities are being canvassed, the more the thought is flickering through my mind that perhaps this isn't a matter for this court, for interpretation.
I have wondered that.
There are some difficult practical and policy questions being raised by these various possibilities that are being canvassed.
Yes, I would entirely accept that, my lord. I would simply remind the court that according to the earlier case law, one has, under Section 3, to read down, if at all possible, in order to avoid making a declaratory.
The trouble is nobody ever says nowadays that it isn't possible.
No.
It says what?
Nobody ever nowadays says that it isn't possible. People always come along and say it is possible.
Well, in the case of Wright that we looked at yesterday, I in the Court of Appeal, produced a rather extravagant interpretation, which was rejected. So it's something that I'm somewhat sensitive to.
I understand that. I think that merely goes to show that some of those solutions on analysis don't work
Yes.
to solve the problem.
Yes.
In this instance,
Whereas these would work to solve the problem.
in this instance, if one applies the phrase which Lord Roger used in an earlier case about something going with the grain of the legislation, here the grain of the legislation, as I see it, is, well, firstly, one has the child welfare principle at the heart of it. Secondly, in the context of family law, one is clearly going to be concerned with other people's Article 8 rights. So that any kind of reading down that makes it clear that the provisions are tempered by the need to comply with Article 8 is, in my submission, clearly going with the grain of the legislation. Precise wording maybe one respects the difficult task that parliamentary draftsmen have. The precise wording may be quite difficult, but my submission is that it is, in fact, possible to read this down in relation to Article 8 if the court is of the view that to refer more broadly to convention rights is unnecessarily unclear. In the context of this case, however, if the court is of the view that the procedure, the two-stage process that I've been referring to is incompatible, then the question would be what order should follow. In my submission, the correct order, given the unusual procedural route by which this has arrived in this court, is to allow the appeal and to refuse the prayer of the reporter's petition, if the court is of the view that the initial order was actually competent from the outset, or conversely, if of the opposite view. Lords and my lady, there was only one point I should have mentioned in case it's helpful in relation to Lord Kerr's question, which is that although not legally qualified, I advise the children's hearing do have ready access to legal advice. So,
expert, no doubt.
yes. Those are my submissions, unless my lady or my lords have any questions for me.
Thank you very much indeed. Mr. Dunlop?
I'm obliged, my lords and lady, but I have nothing to add.
Thank you. Now, Mrs. Scott.
Lords and ladies, I'm most grateful to Lord Friends Wise for providing these draft interlocutors. I'll treasure them on the Sheriff Court bench, but I respectfully submit that they do little other than suggest that the interlocutor which Sheriff Totten drafted can be read perfectly logically and comprehensibly, and that one doesn't really embark on a parsing exercise when dealing with child welfare, and that interlocutor, following these discussions, I invite the court to find was perfectly competent and to deal with this appeal appropriately. In my submission, however, there is still a problem which requires us to move to part 2 of the consideration. The appellant in this case is vulnerable as a result of the history of the matter, and he's also vulnerable as a result of the position in which he's placed by virtue of section 93 2b of the Act. What I attack in this appeal is the link between section 93 2b and section 3, because it's that link that I say causes difficulties in terms of Article 8. And what my learned friend Miss Wise has to grapple with, and indeed the Lord Advocate, is that in the Scottish Children's Hearing we have a forum which is the only forum, as it emerges in the course of this debate, in which an unmarried father has to surmount an additional hurdle or hoop in order simply to be heard, in order simply to be involved and to participate in the decision-making in relation to his child. And I would respectfully remind the court that when we're looking at this, we're not talking about private law rights, as there in a number of these cases we've looked at. We're looking at public intervention in the life of a child and a family. And that the European Court jurisprudence requires a particular protection, legal safeguard for that life. And it's my respectful submission that the structure that we have in relation to the link between section 3 and section 93.2b, by excluding the father from participation without surmounting an additional hurdle, does not accord the requisite protection in terms of Article 8. And that is a freestanding argument. And I take issue with Malone Miss Wise in her submissions, because in her submissions she drew together issues which arose in the Article 14 cases with the Article 8 cases. And the Article 8 point in my submission is freestanding. It's there. Does this man have the right to involvement, or is he involved to the extent sufficient to protect his Article 8 rights to family life? And that's a thread which runs right back to INRA W. In my submission, the Article 14 cases are quite a different issue. And the Article 14 cases, of course, the thread of Inre G, Zarnegger and McMichael. But I take my stance on Sahin, and I respectfully disagree with Malone Miss Wise that that was a case of a veto. It wasn't a case of a veto. It was the case where the European Court found that there was a greater burden placed on unmarried fathers as compared with those who had been married and were divorced or separated. And it's the greater burden that I attack in this particular case. And in both these articles, one, of course, has to identify legitimate aim and test pressing social need against that aim or justification against that aim. And in my submission, in the debate that we've had, it's been difficult to see the pressing social need, not for the attribution of responsibilities and rights, but for the participation in the decision-making process. When it comes to the issue of how does one do this, what I would respectfully offer to the court is a matter I just mentioned briefly at the end of my submissions, and that is that the Children's Hearing and the Sheriff are already involved in making a qualitative assessment of the 93-2C case, that is the care and control case. And I mentioned briefly the case of C against Kennedy, which is at tab 7. This was a case under the old...
Did you say?
Tab 7.
7.
Yes.
Yes.
This was a case under the old Social Work Scotland Act, where an unmarried father had tried to be included within the definition, and the definitions are fairly technical, of a guardian, but the point was he a person, and one can see this perhaps in the rubric on page 1 at the end of the first paragraph, or towards the end of the first paragraph, was he a person who, in the opinion of the court or children's hearing, had for the time being the custody or charge of or control over the child? And what the extra division said in relation to that is on page 71, the bottom part of that page. And to read matters fairly short, it was said by the court that this was a decision for the court or children's hearing which had to determine that question of fact and consider if all the circumstances disclosed to it bear upon that issue as to whether or not the person claiming to be a guardian had at the relevant time the custody or charge of or control over the child. Now, my submission is that that is a model which can perfectly easily be adopted, going with the grain of the legislation and putting in place a relatively straightforward test of convention appropriate involvement. And my proposal in option 2 was I actually thought was lifted straight from the Bink. But I'll leave that to the Modern Lady to examine. That I had read Le Bink, and I may be wrong, of course. I realise Mr. Johnson and Mr. Johnson reads it slightly differently, as that is exactly the test. Is there a family tie?
Yes.
And that was why it was proposed. But of course, if this all proves too difficult and one is looking for a test of certainty, the test of certainty is quite easily resolved by making it parent. And the discussion may well lead my lords and my lady in that direction as being a perfectly clear and compliant test, which actually goes with a test applicable in every other forum. And in my submission, the problem about obligation is answered satisfactorily by section 45(8)(b).
I mean, what does it actually mean? I mean, if one looks at section 93, what would you actually do?
My proposal, I appreciate this is matter for my lords and my lady, would be to add in to section 93 2B.
It's added into A, is it, or
So
C?
it's C, which is the part of the test which already requires an examination of the facts by the
Yes.
children's hearing or the court. I appreciate the reporter will look first.
Yes.
And then if there's a concern, it'll be dealt with by the children's hearing, and it may ultimately have to be dealt with by the sheriff as the matter goes through to the sheriff. As to whether or not it appears, not that somebody has care and control of the child, but that somebody is a person who has a de facto family tie, or whatever the appropriate wording from the BINC might happen to
Yes,
be.
I heard that part. What about parent? What was that? What's that suggestion which you said we might
That was my
retreat to?
first suggestion on page 14 of my case,
Yes,
that one
what
would
is it?
simply be read down 93 2BA to limit it to any parent.
So you read out.
Yes, read out.
Delete enjoying.
Yes, put the red line through and say that now is a consistent
Yes.
test, and it is with the grain of the legislation for all the reasons that I explained in my submissions.
So you would get rid, I mean, you would actually be getting rid of the whole thing, wouldn't you?
Getting rid of the link, absolutely.
No, but
That's
you
what I've
get
been
rid
arguing.
of, but I mean, in 93 2, this bit, a relevant person, I mean, you just stop at any parent.
Yes,
Well,
yes.
I mean, so, I mean, you'd be declaring the entire provision redundant,
You would need
substituting something else.
we would need the rest because
That
one would
looks to me
include foster
terribly like
parents.
amendment.
But you keep B and C.
You keep B and C.
Oh, yes,
You
absolutely.
need B and C.
Yeah, keep B and C.
Because these are people
These
who
are
are
different
not
people.
parents but have responsibilities
Different people,
invested
yes.
in
So
them.
you
Yes,
bring
I
in-
would-
They
you would
would.
really, but you would be striking out the whole of the words from enjoying onwards, plus a little bit that's been
Yeah,
added
sorry.
in already by the extra division.
Yes, but my argument
Take
has
that out
been
too.
that the link is non-convention compliant. And it depends to what extent my lords and my lady accept that argument.
Yes.
And unless I can assist the court.
Well, thank you very much indeed. Well, we're extremely grateful to all counsel for their submissions, both orally and all their presentations in writing. But for obvious reasons, we'll take time to consider our decision.